The topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good evening. Welcome to our launch of the new Ask the Experts. For the last 8 years, we were on another station, and now we are big time now. We are both TV and podcast, which means we've got a new phone number, which I want to give you. It's 561-623-9429. This show, it's usually the first and last Thursday of each month, is our association law. It is probably the hottest show we have in all of our markets. So the phones ring. So if you got a question, whether you live in a condo or an HOA, I consider one of the top law firms in the state of Florida, Kaye, Rembaum. They do association law. So if you've got a question, if you're a board member, if you are a management company, you can give us a call at 561-623-9429. We have the senior partner of Kaye Rembaum. And I can't believe, if you're watching us tonight on TV, you can see our pirate, our one-eyed pirate. There he is. Me with my cold and my cough, and you with your detached retina. Hey, good evening, everybody. And hey, we got to start from scratch. Tell everybody about Kaye Rembaum.
Well, Kaye Rembaum is a full-service law firm concentrating in the area of community association, condominiums, homeowners associations, some mobile home park stuff as well. We've been operating continuously in South Florida since 1992. And we also provide services out of our office in Pompano Beach, Palm Beach Gardens, Tampa, and Orlando. Any aspect of community association operation that communities will need are things that we provide. We do reviews and opinions regarding the covenants, obligations of the association and the unit owners, enforcement of any violations, contract negotiation, construction defect, collection of unpaid assessments, pretty much anything that will come up in an association on a day-to-day basis. Legally, that's what we do.
Well, I got to tell you again, and the phones have already started ringing already. Our number here is 561-623-9429. We are going to be talking tonight, and I've got to get Juan. We have a scroller down at the bottom. And Juan, if you could put up those dates that were given to DJ, so those can scroll down at the bottom. You do a lot of different classes during the month, which we promote on here. And you can either call in or people will actually write in. If you have a question, we have a chat line on the right-hand side of your page that you can send your questions during the show. I will also be reading text that came in for questions. These are all about any kind of problems that you've had at your HOA or your condo. We will have the answers here. So I want to start off. We're going to start off with Bonnie in Boca Raton. Says, "Hi, Robert. I'm a board member and I love your show. Can you clarify, past a 40-year inspection, do we still have to address new laws now or at least the 50-year mark?"
Well, in order for the new laws to affect Bonnie's condominium, they're gonna have to be more than 3 stories, 3 stories or more. If their condominiums less than 3 stories, then the new laws don't apply to it. There are inspections and reports that are required to be undertaken in those condominiums, depending on how old they are and where they're located, as to whether they have additional time or not. But through the end of 2024 is when it ultimately will all come due. There's going to be structural reports that are there's a whole host of items that have to be done, and it really doesn't matter if you've had a 40-year inspection and have passed it, because some of the things that they're looking at are not part of the 40-year inspection. So unfortunately, Bonnie, you're going to have to be participating in that if your condominium's more than 3 stories.
Seems like, Robert, a lot of people want to know if they should start putting money in reserves now and not wait for 2 years. What are your thoughts?
Well, the law has always been that reserves in condominiums for the specified items in the statute, being paving, painting, roofs, and any deferred maintenance of over $10,000, has always been required to be in the budget each year for that portion for the year, given the life of the particular item. The law has allowed owners to vote to waive all or a portion of those reserves each year, and many communities have done that through the years, and just as a matter of course. It was something that the boards have the option to present. It wasn't something that the owners could force. So if the board presented the waiver or reduction of reserves, then owners could vote on that. If, however, they did not present it, it had to be 100% for that year, not 100% of their reserves, just the pro rata portion that would be required if they're doing it over the remaining life of the reserve. My opinion has always been that it's better to have the reserves than to not have them. It enhances the values of the property on resale. And as things are going, it's becoming more and more important, since many of these items are going to become mandatory if the legislation isn't changed in the upcoming session. It can get prohibitively expensive for some condominiums that have greater issues to address. Many condominiums have been around and have maintained sufficient reserves, so they may not feel such a financial pinch, but I think there's a large number that will. So starting sooner is a good idea.
We're going to be talking about the classes that you do each month. If you look down at the bottom of the page, we are also giving you those classes, what day they're on this month and at what time. So you can, and plus Robert will be giving those out down the road. This is, if again, we've had a couple calls already. If they want to call in now, the number here is 561-623-9429. And we're taking calls now. It's hard to take them before the show starts. Now, we're going to go to Jackie in Aventura, and she wants to know, what, if any, are the grounds to disapprove a lease application?
Well, assuming that the board has the power in their documents to review and approve or disapprove a proposed lease transaction, the grounds that are available are fairly large, as long as the board avoids any of the constitutional issues, being race, religion, creed, national origin, marital status, and things of that nature. The best and highest issue would be if the applicant on the face of the application fails to qualify under the provisions of the governing documents. There's for example, let's say there's a provision in the documents that say no trucks, and the person's application reflects that they have a pickup truck and that they intend to use that as their primary vehicle. That application can be disapproved by the board because on the face, it violates the documents. Now, sometimes there's background checks that come up with criminal backgrounds. Using criminal background is something that they can do to an extent, but not just because there's a criminal background. It has to be a convicted felony. It has to be relatively recent in time, and it has to be of such a nature as to affect the possibly affect residing within the community. So there's a number of different issues that could come up, and it's important that when a rejection is going to be made, the board will consult with their counsel to make sure they're not getting themselves into any kind of trouble.
Okay. Again, the phone number here is 561-623-9429. This is the Ask the Expert show. Starting back, we get back on our schedule next month. It'll be the first Thursday and the last Thursday of each month. Kaye Bender Rembaum, their association lawyers, will be with us. And it's usually we get questions from all over South Florida. Though you have offices in Tampa, which you were on our Tampa show, and you just opened up an office in Orlando.
That's correct.
So you've really got Florida pretty well covered. Before you know it, I'll be hearing you've got a new office in Jacksonville. I'm just kidding. You got enough headaches without a fourth office. Anyway, we're going over texts that people have received, have sent us. And in order to do that, all you have to do is you can text me at 954-336-3767. It's a pretty well-known number because we average probably about 30 to 40 texts a month, people who have questions for Robert. Now we're going to go to Amber in West Palm Beach. She wants to know if you've gotten a violation notice and removed it to their satisfaction, then repeat the violation. Are there further steps the board can take? Her second part of her question is, our condo docs don't say anything regarding that.
Well, for any kind of documentary violation in condominiums as well as in homeowners association, the association has a variety of remedies available to it in the statute and typically in the governing documents for addressing these violations. The association, depending on the violation, may depend on which choice the association wants to make as far as how involved it gets, because it could be imposing a fine against the individual. It could be pursuing arbitration with the Division of Condominiums for condominiums, or it could involve court action, which is available for all of these situations. That can be involved in can be expensive. There's also, depending on the remedy, sometimes documents provide for the association to address a physical issue on its own and then assess the owner for the cost incurred in doing so. So the documents have to be reviewed to know for sure the options that are available to the association. Fines can be a good method on small types of violations that aren't ongoing but can recur. Example, leaving the garbage cans out too many days, or not picking up after a dog that goes for a walk in the common areas. You're not going to necessarily file a lawsuit over that, although sometimes if it's sufficiently ongoing and in the face of the board, there could be the desire to pursue some kind of more formal legal action. But fining is often the method that associations use for that. If they're going to go to a more involved type of enforcement, there would be, in a homeowner association, a mandatory pre-suit mediation, which before you can file a lawsuit, you have to offer the violating homeowner the opportunity to attend mediation and provide a list of mediators, and the parties split the cost and try to settle the case before it gets out of hand. That's if you're going to go to court in a condominium, that's typically the approach that will be taken there as well. And if the matter can't be settled in mediation, then it goes into the typical litigation type setting to compel compliance.
Robert, we're going to go to our first break. Tell everybody how they can reach Kaye Bender Rembaum, especially your great website.
Well, the great website is kbrlegal.com. On the main page, there's a contact box you can fill out and for somebody to get back with you. You can call us at 800-974-0680, or you can email info@kbrlegal.com.
We're going to go to our first break. When we come back, we've got more association law with senior partner Robert Kaye. We'll be right back.
Kaye Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several Kaye Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. Kaye Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact Kaye Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com. Kaye Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several Kaye Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. Kaye Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact Kaye Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
For Joe, the first Thursday and the last Thursday of each month, we have the Kaye Bender Rembaum Association Law Firm on with us. It is, without a doubt, one of our hottest shows. Everybody has questions about their condo association, their HOA, and we've got the best attorney to answer for them. We're going to go to Kathy in Lake Clark. She said, we are a 300-unit community. Our documents call for no more than 30% rentals at any time. Current board wants to postpone this further, these leases after January 23rd until we get an accurate number. How can we do this?
Well, it would seem that the board should have a handle as to how many there are if there's a limitation. If they're limiting rentals, but they don't approve rentals, then it would seem that they'd be unable to really enforce that provision or keep track. So first, the documents have to provide for a procedure of application to lease the unit and to get the approval from the association. With that, the association should have on hand a list of all the properties within the community that are being leased. The board would need to rather quickly do its analysis rather than refusing to allow rentals that otherwise would be within the scope of the percentage limitation. And that could expose the association to potential claims of breach of fiduciary duty and possible monetary damages for people who lost out on rent. So it's imperative that the board there get on that as quickly as possible. If they can't figure it out, then they need to just start over and allow leases to continue.
So Kaye Bender Rembaum offers free classes every month, and there's different courses that they offer. We're scrolling right now as we talk at the bottom of the page. But Robert, why don't you give everybody all the dates and times of your classes for this month?
Sure thing. Sadly, there were 2 today that have already taken place, so we don't need to necessarily talk about them, but maybe next time. So the first one upcoming next Tuesday on January 17th at 11 a.m. till 12 noon, Navigating the Florida Insurance Market. What is Senate Bill 2A? That will be a panel discussion hosted by Affinity Management. Michael Bender will be one of the panelists discussing the most recent changes to the insurance market that the special session put into place last month. And then on January 17th at 1:30 to 3:30 p.m., there's a Condominium Association board member certification. By the way, all of this is via Zoom. There's 2 CE credits for that. It'll be taught by Allison Hertz from our Palm Beach Gardens office. That's next Tuesday, 1:30 to 3:30. And then on Wednesday, January 18th at 11:30 to 12 noon, a live presentation at Capriccio's, which I believe is in Plantation, Legal Update 2023. Michael Bender will be there with the networking group to present that information to the participants. There is 2 CE credits for that as well. And on Thursday, January 19th, Attorney Jamboree Q&A panel, 12 noon to 2 p.m. Live via Zoom, panel discussion with industry experts hosted by a networking group. On the panel will be Jeffrey Rembaum and Jeffrey Green. Jeff Rembaum will be talking about general condominium HOA type information. Jeff Green is our board certified attorney in construction law. And then on Thursday, January 26th, Homeowner Association board member certification by Zoom. That will be 2 CE credits as well. That's going to be instructed by Alan Schwartzide out of our Orlando office. So that is the upcoming for the month of January.
If you missed any of those dates, we are right now those dates and times of the courses that Kaye Bender Rembaum offers.
And then go to our website, kbrlegal.com, and click on the calendar and click on the event that you're interested in participating in so that you can register and get the signing credentials for the Zoom.
There's a lot of great information on your website. Mine's the morsel, so.
Mine too.
Yeah, I love that one. Okay, let's get back to the show. Here's Victor in Boynton Beach. Robert, our condo board wants to install pavers around our pool area, which is very costly and will charge the appearance and materials that are now there. Change the appearance and materials that are now there. Is this considered a material alteration?
And did he say this is a condominium?
Yes.
Okay. Yes, it is a material alteration. Whether or not a unit owner vote is required for that to happen is something that will be laid out in the documents themselves. The statute provides no material alteration or substantial improvement to common elements can be undertaken except as provided in the declaration. If the declaration is silent on any owner approval or anything having to do with that, then it requires a vote of 75% of the owners. So you'd have to look at your documents to see if there is any reference to material alterations and whether it identifies a dollar figure or allows the board to do it or provides for a percentage of owner approval, or if the statutory default 75% is going to apply.
Okay, apparently we got a lot of comments on YouTube right now, and I'm going to have Juan go ahead and put them through. Thank you for updating me on that. Is it possible for a board of directors to over communicate to its owners? Can it bite the board in the behind?
Well, it is certainly possible for the board to over communicate depending on what they're communicating about. If there's pending litigation or potential litigation, it's important that these types of informations that the attorneys involved with remain confidential within the board. And if there's going to be general communication to the community, and the association has an attorney that they work with, it's not a bad idea to periodically run that by the attorney to make sure that nothing is being said that could come back and create a legal problem for the association, because the board was a little overzealous in wanting to be communicative and open and above board. There is open, and then there's too open.
Yeah, I understand that. Let me give out the phone number again. It's 561-623-9429, 561-623-9429. If you have a question, now is actually the best time to call into your question, because I'm telling you, a couple months from now, it'll be tough getting in the show like it has been on our previous shows. Let's go to Lupino in West Palm Beach. I take it Lupino is a ma'am, M-A-M. We have a new property manager that has taken $148,000 from reserves and used it in operating funds. Is that legal?
It doesn't sound legal. First off, the property manager shouldn't be having access to the association's funds to be moving them around unless the board has given such instruction and approval. So the issue may be the board is doing something wrong. Reserves, if they are in a condominium, are not allowed to be used for anything other than the purpose that they're being held for, unless there's a vote of the unit owners to use them for a different purpose before they do that. So if they're using the reserve funds to pay an operating deficit, that would be in violation of the statute, and it could end up, if anyone makes a complaint to the division, subjecting the association to significant monetary fines, which all the owners are going to have to pay their proportionate share. So it's important to get to the bottom of that reserve issue. If there's an association attorney for that community, the board should be getting with their attorney to head this off as quickly as possible.
We're going to go to the chat line now. Our co-op board meetings are audio recorded. Do all shareholders have rights to access these recordings without impediment?
The issue with recordings, the issue with recordings from board meetings are depending upon how the recordings are being used. If the recordings are being used to assist the secretary after the meeting to remember things that happened, to create the minutes, and then they could be discarded, then the answer would be no. But if the recordings are being used as an official record of the meeting and retained by the association, then they would be open to inspection or listening to by the unit owners. Recording of meetings by the association is generally not something that should be necessary, and it's certainly not recommended. Minutes of a meeting is not supposed to be a transcription of everything everybody said. The minutes are supposed to be who's there, what motion was made, how the vote went, and what actions were taken by the board. Nothing more. Anything more in the minutes is like that question about too much communication coming back and biting the association in the butt. We've seen numbers of times when minutes have too much information and the association gets involved in some litigation that involves the issue that the minutes were addressing, and those minutes were used against the association in the litigation. That wouldn't have happened had the minutes been just the normal form of minutes. So that is something that we advise care relative to recordings.
Okay, let's go to Cindy in Boca Raton. Cindy, thank you for writing. Robert, our board never misses one of your shows. Thank you so much for everything you do. If our docs have the Kaufman language from time to time, written several times through it, is that referencing just that particular area, or does it pertain to the whole document?
Well, the answer, unfortunately, is it depends on where it is and how it's being used. Oftentimes, we'll see individual sections are amended in a way that include the language and that applies just to that particular section. Other portions can be more global in their application, so it really depends where it is in the documents and the context in which it's being included. So unfortunately, I can't answer yes or no based on the information of the question, but it is possible that it's just for the specific section, but it's also possible it could be global.
Here's Bob in Pompano Beach, where your home office is. Can the president of the association use association attorney to go after a unit owner for defamation of character?
Defamation is generally an individual personal cause of action of the board member in most instances. It's not a typical function of the corporate entity, the association, to provide a plaintiff position for an individual board member making a claim of defamation against a unit owner or a member of the community for something they said or wrote. That's the general advice we give. Under the facts and circumstances, it may be appropriate if it involves something that is more the association than the individual board member. So the facts and circumstances of the alleged defamation are going to have to be considered before you could give a blanket no on that.
Okay. Hey, we have a line open right now at 561-623-9429. If you have a question for Robert, you might live in a condo or an HOA, and you have a question, boy, this is the right time to do it right now.
Before everybody rediscovers us.
By the way, Happy New Year, everybody. I didn't even wish you know, Robert and I have been doing this for about 5 years now. And
no, it's more than that.
Has it been more than 5 years?
I think we started in 2016-ish.
Wow. Anyway, if you're watching us on TV right now, you can see the one-eyed pirate with us. What's that feel like with just seeing out of one eye?
Well, unfortunately, if I take the patch off, I still am only seeing out of one eye. Yeah. So it's not terrible, but I find that with one eye by itself, I don't see as well as with both eyes together. Like if I just had the right eye, it's not as good. If it's just the left eye, it's not as good. But if they're both working, it seems to work perfectly. So I'm looking forward to the vision.
Got a caller. Let's go to our phones. Hello, caller. Are you there? Caller, are you there?
Yes, I'm here. Can you hear me?
Yes.
We can hear you fine.
Yes. Good evening. I'm calling from Miami. Condominium. If these are not tenants that just left in a unit, can the association evict these people? Or no? They don't have a lease. They were with somebody and they left there.
So I understand you have someone occupying a unit that was living there with a approved tenant. The approved tenant moved out and they're still there?
Yeah, I think they were living there with the owner or some owner give them agreement, but they are causing a nuisance in the community. Can the association evict these people even though they don't have a lease?
Unfortunately, that's going to depend on your documents. Your documents have to give the board the ability to actually evict. If you don't have the ability to evict, then you would have to bring legal action against the owner to get an injunction that compels the owner to evict the tenant and or the occupant, whatever they are, which takes a little longer than a straight eviction. So you got to have the association attorney confirming your documents whether or not you have the specific authority to act in the place of the owner and evict the occupant, or if you have to do the roundabout way of getting an injunction to compel the owner to do it.
Okay, thank you. One next question.
Sure.
What is the exact process to give notice for delinquent or arrears members? I'm going to hang up and just listen to you.
The process for giving notice to delinquent owners in a condominium requires first the association to send. The process for giving notice to delinquent owners is going to the owners have to receive a 30-day notice from the association that's on a form that's specific to the statute. So we don't advise just send them a letter. You have to follow the statutory language that includes the specific information of the unpaid assessments. Every installment that might be delinquent has to be reflected either in the face of the letter or in an attached ledger for the account. And once you've done that and the 30 days have expired, then you can turn the matter over to the attorneys that would first send a notice of intent to lien, which is a 45-day notice by statute that says if their account isn't resolved within 45 days, then a lien would be filed, and all attorney's fees and costs incurred in the process are included in what the owner owes. Then at the end of that 45 days, you file the lien, you have to give another 45-day notice of the intent to foreclose on that lien if the account is not resolved. So then hopefully the owner works it out by time that expires. And then at the end of that time frame, you can then commence the foreclosure process, which requires filing a lawsuit. Once you file a lawsuit, you have to have the paper served on the individual, personal service handed to them. If you can't find them, it may require publication, which draws out the process. So that can take anywhere from 4 to 12 months, depending on the court and what kind of defense, if any, the owner puts up to the claim. So that's the nutshell process for collecting.
Robert, we have callers on the phone. Let's do. We got to take a break, and a little bit different when it's TV. We got to take a break right now. It's our last break. Callers hold. We will get to you as soon as we come back from break.
Kaye Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several Kaye Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. Kaye Rembaum is also a well-known provider of free legal education for managers and board members. Contact Kaye Rembaum today by calling 800-974-0200 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. We're here with Robert Kaye. He's the senior partner at Kaye Bender Rembaum. We're talking association law, condo, HOA. Let's go to the phone. Let's take our next caller.
Yeah, I know you did it for yourself.
Caller, you're...
Hello?
Hello?
Yes, I'm right here. We're going to give you the question right now.
Okay.
We are a condo building with 16 units.
Co-op. We're a co-op.
We have a co-op owner that has sent us a registered letter with at least 15 complaints and demands, ranging from personal to rules and regulations. Our question is, does the board have the right to distribute the registered letter to all condo members?
Well, it sounds to me that all you have is correspondence from one of your owners, and there's nothing that's confidential about it that would preclude the board from sharing the content with all the owners. It's part of the official records of the cooperative and open to the inspection and copying of any requesting owner. So by virtue of that, there's no legal impediment or restriction from the board distributing the communication to all of the members of the cooperative.
Can we do it in a public meeting of all the association?
Could we do a public meeting?
Well, is your intent to try to publicly shame this person or create some form of animosity?
No, we just want to make sure that all the condo knows, right? So that, you know, and one of his demands, he says, accept these demands at a properly noticed public meeting of the board and include the acceptance in the minutes of the meeting. So it's almost like he's asking us to do this.
Well, he's asking you to admit in a meeting as opposed to just inform everybody of his demands. But I don't think there's going to be any blowback from him if you do that.
Okay. Well, that's our question. We just didn't want to have any, his demands and questions are mostly about rules and regulations and you know, they're like, 15 questions. They're pretty intensive. But we wanted to respond to him on each question, but we also wanted to let all the members know that he had all these questions. And it's, basically he sent it from a lawyer, and he called it a pre-suit notice and request.
Do you have an attorney that represents the cooperative?
We do.
Yeah,
You are.
Okay, well, I was going to recommend that you get in touch with your attorney and provide him with that letter and make sure that your attorney agrees that everything in it it's okay to incorporate into your meeting before you go ahead and do that.
Okay.
So it's good for us just to respond to the letter saying we received your letter and the board is working on all your demands, and leave it at that for now?
I wouldn't say working on, I would say considering and reviewing.
Bingo. Considering and reviewing. And then we're going to just call you guys and we'll continue on if they keep pushing the button.
Okay. Thank you.
Sounds great. Thank you so much.
You're welcome. Thanks for listening.
Well, you just made somebody's day. Okay. We have a line open now at 561-623-9429, or you can actually, there's a chat line on the right-hand side of the page if you want to send a question in for Robert. We're also going through right now texts that we received. Here's one from Fred in Palm Beach. He has a condo. I have never heard this, Robert. International screening costs $200. Who pays the additional $50 since we are limited to $150?
Okay, well, what you may know is that people get background checks on applicants for sale or lease. And oftentimes you have people who aren't from this country who are making the application. So they have a service they found that can do the background check internationally, and it costs more than the $150 that they're limited to by statute. The unfortunate answer to that question is the association has to absorb that $50 because the statute doesn't allow them to charge more than $150. They should be happy to know that recently it was increased from $100 to $150. So at least the legislature has recognized that the old $100 doesn't go as far as it used to. Okay. Unfortunately, that would fall under a cost of doing business.
Well, unfortunately, we are coming to the end of our first TV podcast show. Tell everybody your phone number and give them your website.
Well, you can reach us at 800-974-0680. You can write to us at info@kbrlegal.com or go to the website kbrlegal.com, and you'll find on the first page a contact box to fill out, and you'll receive a response to that within a day of you doing so.
Well, I hope your Mrs. Kaye is happy that she's got you a little bit earlier now on Thursdays.
Oh, she's thrilled.
Yeah. Anyway, you will actually be back with us again next week because we missed a day last month.
Well, it won't be me, but somebody.
It'll be somebody. Okay, we got to go. We will be back with you next Thursday with more Ask the Experts at 5 o'clock Eastern Standard Time. Everybody have a great weekend. It's going to be cold here in South Florida tomorrow. We'll see you next week. Thanks, Robert. Feel better.
Right, thank you. Thank you.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.